Hello, everybody.
Kyler Benton.
This is case number 251973SM, the people of the state of Michigan versus Kyler Joseph Benton. Mr. Benton, what's a good mailing address for you?
Correct.
Do you have a good telephone number?
Yes, I do. 231.
Did you have the opportunity to meet with somebody from the public defender's office today?
Yes, I did.
I have a complaint that alleges that on or about May 19th, 2025 in the city of Cadillac here in Wexford County, it is alleged in count number 1 that you did commit the offense of domestic violence upon Jody Shenowa. So that is a 93-day misdemeanor and or a fine of $500, and a consecutive sentence may be imposed if that occurred in a place of confinement. Do you understand those charges and potential penalties?
Correct.
Did you read and sign an advice of rights form at the jail, talk about your rights to a trial and your rights to an attorney?
Yes, I did.
Did you understand those rights?
Yes, I did.
You have the right to be represented by an attorney at all phases throughout this process. If you could not afford one would be appointed to you at public expense, but you may be required to repay a portion of that expense. Do you understand that?
Yes, sir.
Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Request.
And what is your current source of income?
Work here in Cadillac.
Where do you work?
Working underneath a friend's LLC.
What is it?
I'm working with my friend. He has an LLC. I'm just a laborer.
I forgot to ask, do you have an email address?
Yes, I do.
The court will make a referral to the public defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf and set the matter for a pretrial. That is where the prosecutor and your attorney will get together and see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing in future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, I'm not sure if you both have received the praxis or not. I've received it, I reviewed it. He does come back as a 3, which shows medium risk. In the defendant's past, I show in 2011 an operating while visibly impaired, in 12 an attempted B&E with intent, 13 retail fraud third, 22 a domestic violence and an attempted joyride. 2 cases handled under HIDA in 2011. In 15 out of state, there was an OWI and a drug test falsification device, all out of state. Mr. Hartel, any comment regarding bond?
Yes, Your Honor. I'd ask the court to consider the practice.
I'm sorry, Mr. Benton, you had your hand raised?
Yes, sir. Can you make me aware that I've turned myself in multiple times when the court asked me to, when I was going to jail, as well as those 2011 cases, which were felonies. I've also turned myself in. There was never a time where I have ran from and not came back to the courts.
Okay, thank you, Mr. Hartel.
In addition to that, Your Honor, I'd ask the court to consider having the practice be read as a 2 when it mentions the different addresses. I realize the notes say they stated on and off, but for clarification, what he explained to me is the address that he gave is one that he primarily lives at. He tells me he was staying with another person, I believe the alleged victim in this file. But I would consider that more as permanent address. So I would ask the court to take that point away and view it as a 2. I, of course, trust the court's discretion on that. Either way, I would ask the court to consider a personal recognizance bond. As he did note, he does have work lined up with a friend of his. He does have ties to the community, no matter how we end up scoring those ties to the community. I don't believe he's a flight risk, in part because of what he said about how he has turned himself in the past. I do realize that he does have some prior convictions and the court has to give that some weight. But I do believe any concerns the court has can be overcome with bond conditions other than monetary ones. Because even with a good job, because he hasn't been doing it for a significant amount of time, he does not have any significant savings from that. No contact with the alleged victim seems like a reasonable thing. He's advised me that if the court ordered that he would obey that. The address he's going to go to is a totally separate address. any other conditions the court wanted. I, of course, would respect. I don't believe there's been any allegations of drug or alcohol, but I'll trust the people to correct me if I'm wrong. Thank you.
Thank you. Mr. Benton, without discussing any facts of the case, where do you reside?
I reside primarily at, that's my primary address. And I was staying with,
Okay, so your address, approximately how long have you been staying at Marble Street?
3 years, 4 years.
And in that 3-year time period, how long would you say that you actually spent the night at Marble Street?
80% of the time, 90% of the time.
All right, I will go ahead and I'll readjust that, Mr. Hartel. So that will drop the praxis level down to a 2, which puts him at low risk. Oh, well, I guess, Ms. Lawrence, any argument against that?
No, Your Honor.
All right. People's position on bond?
Thank you, Your Honor. It is reported that the defendant tackled and punched the victim in this case. She was observed to have visible injuries, including a scrape on her elbow, swollen and bruising wrist, and a bloody nose as well. Given these things, as well as the defendant's prior criminal history, including a domestic violence just a couple years ago, the people would ask for a $500 bond and no contact with the victim.
Mr. Benton, when I asked you about your employment, you said do you work with this friend or you have work lined up?
No, I am working, like, I was getting picked up Monday morning to go to the job and this whole situation happened.
And
I work
how long
with
have
him.
how long have you worked with him?
Week and a half. Week and a half. Well, yeah, yeah.
All right.
Last week and then this week, start of this week. Like, I haven't even got a check yet, so I couldn't even make bail.
Roughly how much do you make an hour when you get paid?
$18 an hour.
All right, and do you pay rent?
Yes and no. It's really up to
Explain.
my mom and how she feels at that current point in time.
All right, okay. As I am going to release you on a PR bond, which means you're not going to have to post any money, but I am going to impose the following conditions. One, that you appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. Additionally, I'm going to order that you not have any contact with Jody Chenoweth. No contact means no contact of any kind, not by you, not by phone, not by text, not by Facebook, not by social media, not by anybody on your behalf. Do you understand that?
Absolutely.
I'm also going to order that you be placed on a GPS tether for location purposes only. Ms. Lawrence, was there any indication of alcohol use or anything?
Not to my knowledge.
All right. Mr. Benton, when you are released, you'll need to come over here to Community Corrections to get signed up for your requirements. Just a reminder that if you do violate your bond, you could be arrested without a warrant, brought back to jail, and have your bond revoked. Do you understand that?
Yep.
All right. Next arraignment. This is case number 251935FY, the people of the state of Michigan versus Scott Allen Brookshire. Mr. Brookshire, what is a good mailing address for you?
Cadillac, Michigan, 49601, Your Honor.
And do you have a telephone number? Did you have the opportunity to meet with somebody from the public defender's office today?
Yes, I did, Your Honor.
I have a complaint that alleges that on or about April 9th, 2025 in the city of Cadillac here in Wexford County, it is alleged in count number 1 that you did commit the offense of possession of methamphetamine that is a 10-year felony and or a fine of $15,000. The prosecution has elected to charge you as a second subsequent offender, which makes that 10-year a 20-year and the $15,000 a $30,000 penalty. In the alternative, they've also elected to charge you as a habitual fourth offender. That means that you have at least 3 prior attempted or completed felonies in your past. And that is going to make the 10-year felony a life offense if convicted under that. Now, however, they have to choose whether or not they're going to move forward on the tab 4 or the second sub. They can't try you on both. Do you understand that?
Yes, I do, Your Honor. Thank you.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you write or say can and will be used against you. You have the right to have an attorney present at any questioning that you consent to, and that you have the right to stop any questioning. You also have the right to be represented at all phases throughout this process. And if you could not afford an attorney, one would be appointed to you at public expense. However, you may be required to repay a portion of that expense. Do you understand that?
Yes, Your Honor.
Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Appointed, please.
And what was your source of income?
I'm actually just started a job 4 days before I got arrested to come in here on my probation violation, Your Honor.
Where was that?
I was at the Kingsley Club in Kingsley, Michigan. But obviously I lost that job.
When were you brought in for your probation violation?
April 9th, Your Honor, and my out date is September 21st.
All right. The court will make a referral to the appointment of, to the public defender's office for the appointment of an attorney. Will enter a not guilty plea on your behalf and will set the matter for a preliminary examination. The preliminary examination is a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove two things. One, probable cause that the crime had occurred, and two, probable cause that you were the person who committed the crime. If the prosecution is not able to do that, the case would be dismissed. If they are able to do that, you'd be bound over in order to stand trial in circuit court. Prior to the preliminary examination being held, a probable cause conference will be held. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case. Do you understand that?
Yes, Your Honor.
You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Mr. Brookshire, when did you say your out date was?
September 21st of this year, Your Honor.
All right. And that was for probation, correct?
Probation violation, my first one in almost 2 years, Your Honor.
All right. Any comment regarding bond, Mr. Hartel?
Yes, Your Honor. Knowing that he can't get out until well into September, he has advised me that the staff of the jail have advised him that if he gets a PR bond, he can continue to be a trustee. He is wearing his red trustee uniform at the moment. I haven't independently verified with the jail if that's how that actually works or not, but I trust him to know that information. With him already serving a probation violation sentence, I don't believe he'd get credit for this no matter what we do, if I understand the way that works correctly. I would ask the court to consider a personal recognizance bond, even though that definitely means he's released on this. I know he's not going to go anywhere. And if it can help him be able to be a productive member while he's there in the jail, I'm sure the other jail staff would even appreciate that. Thank you.
Ms. Lawrence?
Thank you, Your Honor. I do understand that bond is somewhat of a moot point in this case, but this was a probation search, which methamphetamine was found in his bedroom. Given the defendant's prior criminal history, including multiple drug offenses as recently as 2024 and 2023, we would ask for a $50,000 bond and random drug testing.
Thank you. So looking at the defendant's history, I show in 2012 an attempted larceny in a building, 2012 operating while visibly impaired. In 12, an attempted larceny in a building and retail fraud second, 13 possession of narcotic less than 25 grams, 19 possession of meth, 2 cases of that. In 22, a joyride. In 23, a possession of an analog. 24, possession of narcotic less than 25 grams as a second offender. And then in 04, in our record, local record, a driving license suspended. State law does require that if somebody has 2 felonies in their past within the 5 years, that the court set a monetary bond. Additionally, one other thing I'm supposed to look at is the likely sentence in this case. And while my scoring doesn't hold any weight when it comes to plea agreements or sentencings in the circuit court, based on what I know of the case and the defendant's history, if he were convicted as charged, I calculated his guidelines at a 10 to 46 as the had 4, not taking into account the second sub. As such, I find that a monetary bond is necessary pursuant to state law in this matter. However, before I get to that amount, Mr. Brookshire, if you do if you are in longer than your sentence and you are able to make bond in this case, you are ordered to appear as ordered, keep your contact information current, not leave the state without permission, and to commit no crimes. Additionally, I'm going to order no illegal controlled substances, including recreational marijuana, and you'll be subject to random testing. When it comes to a monetary bond in this case, normally I would agree with Ms. Lawrence that a high bond would be necessary. However, we know that the defendant is not going anywhere until September, barring any unforeseen circumstances. So I'm not going to set bond that high, but I will set a bond in the amount of $25,000 cash surety. Several factors go into that. The defendant's history, what he potentially scores at, and the fact that he was on probation at the alleged time of the offense. Anything else, Mr. Hartel?
No, thank you.
Ms. Lawrence?
No, thank you.
Thank you, Mr. Brookshire.
Thank
Next
you,
to
Your
Raymond
Honor.
Jail.
Be safe, be well, sleep sweet, and much love.